All right, thanks for taking your seats. We're going to get going here. The final panel. 6-8 months ago, when we were starting to plan to put this together, we had a conversation about various topics for the various panels. And a theme that came up, and I want to thank Court Wold for introducing it, is we've got all this science and technology, all this energy production, all this economic minerals, all this interest. But as Andy said in a previous panel, doesn't do you any good if you can't get to it. And so there's all kinds of questions and interests about how we might develop this with our various land ownerships and interests and competing interests. And that brings us to this final panel on surface issues. And the moderator on this panel, who's going to take over from me, Temple Stolinger, is Associate Dean and a Wyoming Excellence Chair at the University of Wyoming. So welcome to Temple and her panel.
Great, thanks, John. I'm just going to quickly introduce our panelists. You'll find their bios in the program. They're all distinguished in their own right, so please do take a minute to read more about them. The order of the day for our quick hour panel is everybody's going to give about a 5-minute overview on different topics given their expertise. And then I've got a series of questions that we're going to ask that will allow for multiple folks to weigh in at a time. And then we'd be glad to open it up to questions from the audience. So we're going to start today with a quick presentation by Phil Lowe. Sorry, Phil. Phil is a senior attorney with the U.S. Department of Interior in the Rocky Mountain Regional Solicitor's Office. After Phil, we'll hear from Dr. Brian Leonard, my new colleague in the Help School. Brian's the SER Associate Professor and Chair, and he has a joint appointment in the Help School and the School of Energy Resources. After that, we'll hear from Dr. Joe Nicholas. Joe is the Chief Operating Officer for Frontier Carbon Solutions. And then last but not least, Esquire Jim Magagna, Executive Vice President of the Wyoming Stock Growers Association. So Phil, we'll start with you.
Thanks so much, Temple. Before I start, the most important thing I have to say is I'm an attorney with a federal agency, and so don't believe a word I say. Now, my remarks are my own. They are not the official policy of the United States, the Department of Interior, or the Solicitor's Office, or my most favorite client of all, the Bureau of Land Management. So with that disclaimer out of the way, this is about the future, this conference. And you know what Yogi Berra said about the future, right? Predicting it's really hard, especially when it hasn't happened. And so I'm going to take us back to the past just to figure out where we are with federal land management. And many of you know the Bureau of Land Management in Wyoming manages 18 million acres in Wyoming. And more than 40 million acres, more than 40 million acres of minerals. So that's a big landlord there. So where did they get the authority to do this? We look at the Constitution, right? Article 4, Section 3, Clause 2, for any lawyers out there. That's the property clause. Basically says that the United States Congress shall have the power to make rules and regulate the property of the United States. So you have the property clause in the Constitution, and then you have the first land management organization, the General Land Office, back from 1812. And that was all about, if you go into BLM, you look at the GLO maps, that's from the General Land Office, and that was mainly about getting rid of property. And then we go through a series of laws from the mining law of 1872. Again, it's how do we manage and regulate the property of the United States? And there was another big property law in 1872, and Professor Temple knew it right off the top of her head. Anybody else out there? What else happened in 1872? Pretty important in Wyoming. That national park? Yellowstone, right? So again, that was all under the property clause. So we go through a series of acts, the Antiquities Act, The Mineral Leasing Act, important one, 1920. The Taylor Grazing Act, very important for Jim Magagna and his group, 1934. 1964, the Wilderness Act, the Land and Water Conservation Fund Act. All of these things come from the property clause. And then in 1969, we had NEPA. NEPA did not come from the property clause because it was about, and it's not the National Environmental Protection Act, right? It's the National Environmental Policy Act. So NEPA is all about when federal agencies make decisions that they disclose the impacts of those decisions and have public input on them. And so then right after NEPA, we had the Clean Water Act, the Clean Air Act, the Endangered Species Act. And then in the 1970s, in early 1970, Public Land Law Review Commission. It was a really important time. All these new environmental laws coming out. The Land Law Commission comes out with a report called 1/3 of the nation's land. And it was a report on public lands and what should be done. And people were thinking, you know what? BLM lands are kind of trashy. There's not good opportunities there. And so the first statute that Congress started looking at was to increase recreational opportunities on public lands. It didn't get passed, but that is the origins of FLPMA, the Federal Land Policy Management. And what FLPMA does is it provides obligation for the Bureau of Land Management to manage public lands in accordance with a principle of multiple use sustained yield. Easy to say. What is it? Courts have been working that out for a long time. But FLPMA has a couple of big pieces too. So Title II of FLPMA says that the Bureau of Land Management has to have land management plans to take into account conditions on the federal lands. And there's also a corollary to FLPMA, that's NIFMA, National Forest Management Act, but we're talking mostly about FLPMA here. So Title II says you do land use planning. BLM has a whole handbook, if you want to look, the H1601 handbook, all about land use planning, more than you'd ever want to know. Basically saying this is zoning writ large for the federal government. Title IV of FLPMA, which I barely deal with because I don't deal with a lot of range management, but Jim is going to talk a little bit about that. But that's all in Title IV of FLPMA. Title III of FLPMA provides for licenses, easements, use. You want to use federal lands? If it's not authorized by one of those statutes under the property clause, the Mineral Leasing Act, Mining Law of 1872, you look to FLPMA. Title III allows you to get licenses, easements, permits, but Title V of FLPMA provides for right-of-ways. And that's really important, as we'll see as this evolves, because we've taken this stroll through the history of what's going on, but we don't have clear statutory authorization for new technologies. Where in the Mineral Leasing Act does it say anything about carbon sequestration? Where does it say how to authorize wind power on federal lands? We're doing all of that stuff under Title V of FLPMA right now until we get clear regulatory guidance from Congress. And so we've gone through this history. There were a couple of cases this summer, really big cases. Anybody heard of Loper Bright? Kind of like a buzzword. Come on, there's some lawyer in the room who's got to have it. There we go. Yeah, Keith, you know it too. Come on. Loper Bright. That dealt with national marine fisheries regulations. But what Loper Bright did was take a long-standing doctrine that the Supreme Court called Chevron doctrine, out of another case that says we defer to federal agencies' interpretations of what Congress could do. Loper Bright says, not so fast. Congress better be explicit on what happens. So the future is Congress is going to have to step up and do a much better job now that the Supreme Court has said, agencies, you can't just do whatever you want. So.
Great. Thanks, Phil. Phil just taught my public land law in 5 minutes. So that was great, Phil. Thank you for providing that context. Next up, we have Dr. Brian Leonard, who's going to talk more about the scope and nature of different types of surface impacts on federal public lands.
There we go. Thanks, Temple. Yeah, I think I just have 2 high points I want to hit because Phil set the bar pretty high and staying on time, right at the 5-minute mark. So one thing I want to think about is just kind of the nature of surface impacts from different energy technologies, and then thinking about the institutions for negotiating surface access given those impacts on different types of land, without trying to retread Phil's ground too much. So, thinking about the broader context of federal policy and really just kind of broader trends in society at the moment, there's a real push towards decarbonizing the U.S. energy sector, decarbonizing the grid globally. I'm not really interested in weighing in on whether that's a good idea or a bad idea. But if you look at those scenarios for what it would take to reach these kind of net zero by 2050 goals, it requires building a massive amount of solar production, wind generation, and a lot of transmission infrastructure. And so the fundamental problem of the energy transition, if we're going to take it seriously, is figuring out where to put all of that stuff. And the thing that I really want to emphasize about that is that the footprint of renewable energy typically is much larger than the footprint of conventional, say, oil and gas drilling. So a few kind of back of the envelope calculations I did last night on a cocktail napkin, so don't hold me to this. But if you think about the size of a typical well pad, which is usually less than an acre, and you think about the amount of the amount of oil or gas that's going to come out of a typical well, and the amount of energy you can produce with that oil, and then you compare that to a typical solar farm or a typical wind farm, again, speaking in broad averages, the amount of land it would take to generate a megawatt hour of energy via solar photovoltaics is about 10 times the amount of land, just in terms of the site of energy production, that it would take to do that by extracting a barrel of oil from the ground, or not, it'd be many barrels of oil. And if you look at wind energy, it kind of depends on how you look at it. If you look at just the site of the turbines, of course, the footprint of wind energy is very small. But if you think about the site of a wind farm, the footprint of wind energy to produce that same megawatt hour of energy is about 60 times what it would take to produce it with natural gas. So that creates real trade-offs, right? So there are a lot of folks who are very concerned about climate change, and that's the primary goal. But as I said, building these things takes up a lot of space. And so that's going to create trade-offs with habitat for wildlife. It creates visual impacts to sort of the scenic value of the landscape. It creates health impacts, both from conventional sort of oil and gas technology, but also from things like flicker from wind farms. So there are a lot of sort of impacts that we really need to think through if we're going to take something like the energy transition seriously, and make kind of apples to apples comparisons. That's kind of all there's time to say about that in a 5-minute spiel. But the other piece that I want to mention is that thinking about how we navigate those trade-offs between cleaner energy versus surface impacts really depends on who owns the land. So this is particularly true, right, when it comes to subsurface minerals, whether they're fluid or solid, whether we have split estate or not, whether you're negotiating with the mineral owner, and that might be a different person than the surface owner. And the institutions for doing that look very different on private land versus on public land. So Phil sort of outlined what that might look like on public land and some of the policies that are going to govern that. But it actually looks very different on private land. And on private land, typically the mineral estate is dominant. And so it becomes a contractual question of what type of consideration is due to the surface owner. The final thing I kind of want to emphasize under that heading is that actually looks pretty different for renewable energy as well, because whereas for hydrocarbons or solid minerals, you're thinking about a mineral owner versus a surface owner. Typically, when you're writing a lease for a wind farm or for a solar farm or something like that, you're dealing directly with the surface owner. And so you actually tend to not face this same split estate problem. So again, the way we think about negotiating those trade-offs as a state and as a country looks very different for different types of technology, partially because the institutions are different depending on which technology we're choosing to pursue. I think we'll get into it more later.
Great. Thanks, Brian. Next up, we have Dr. Nicholas, who's going to talk to us about his project and some of the challenges new technologies have with the surface estate.
Thank you, Temple. I would like to begin by thanking the University of Wyoming, the School of Energy Resources, and the Wold Foundation. So Peter, Jack, and Court, thank you very much for sponsoring such an event. certainly a unique opportunity to have both industry, students, regulators, and other interested parties in the same room to be able to talk about these issues. My name is Joe Nicholas. I was raised here in Wyoming, went to school at University of Wyoming, got a chemical engineering degree. And since that point in time, I've spent the majority of my career in the energy industry, predominantly in upstream oil and gas. A good portion of that operating in some enhanced oil recovery fields here in the state of Wyoming. So a lot of experience with CO2 in terms of enhanced oil recovery. I gave a talk at Wyoming Energy Authority a couple months ago, and before I went, my wife said, "Don't lecture the crowd." But since I was introduced as a doctor today, I feel like I now have the green light. I'd like to follow up on what Peter talked about today, because I think it's important in terms of understanding why carbon sequestration is something that could be very important to the state of Wyoming. And yeah, it's the importance of minerals. So you can look up this information from Petroleum Association of Wyoming, from the state of Wyoming's revenue forecast, from the Craig forecast. But in 2022, the mineral industry paid over $1 billion in property taxes to the state of Wyoming. So over 50% of the property taxes. That same year, over $1 billion in severance taxes, which is $2 billion. And so if we just do some back of the envelope calculations and we think about what does that mean for me as a Wyoming resident, $2 billion divided by 500,000 people is $4,000 a person. So I have 3 kids, and my wife and I, 5 people in our family. That's $20,000 a year that the minerals industry subsidizes us. You look across campus for the students here, $1.5 billion of infrastructure since I went to school here. The Hathaway Scholarship, a very affordable education, all because of the minerals industry. And as Peter mentioned, our minerals are predominantly exported. And the people that are purchasing our minerals have said that they do care about the carbon footprint of our minerals. And so when we think about the different alternatives for reducing those carbon emissions, carbon sequestration is one of them. The project I work on at Frontier Carbon Solutions, we have a carbon sequestration project in southwestern Wyoming at the corners of Sweetwater, Lincoln, and Uena County, of roughly 100,000 acres. 45,000 acres of that, we're working with the BLM to attain a right-of-way, for the pore space, which we can talk about later today. Within 25 miles of us, there's 9 million tons a year of CO2 emissions, and we think that's a proper distance to be able to pipeline those emissions to our hub. The thesis behind our project is that sort of the hub and spoke model gives industry the best chance of lowering the cost of capturing that carbon. We have received the first 3 Class 6 permits in the state of Wyoming. It's about 20% of the Class 6 permits have been issued nationwide. Those are the permits that are required to dispose of CO2 in a saline aquifer. And we are partnered with the School of Energy Resources on a DOE grant, which we have just received final funding on, $50 million, and another $10 million. $9 million has been put up by the Wyoming Energy Authority to go and drill 3 wells out here to characterize the site. Happy to talk a little bit more about our project as we get on through the day, but I'll turn it over to the other speakers.
Great. Thanks, Joe. And last up, we have Jim Magagna, who's going to talk to us more about considerations of working with other existing users of the surface and adjacent landowners.
Well, thank you, Tim. I appreciate the opportunity. I feel compelled to begin by disagreeing strongly with the opening statement by my good friend Phil Lowe down there, when he indicated that the most impactful event of 1872 was the creation of Yellowstone National Park. We firmly believe that the most impactful event of 1872 was the establishment of the Wyoming Stockgrowers Association. With that, to move forward, and maybe that is a pretty good lead-in too, because one of the things that I respect that the energy industry has faced in the past in Wyoming, I think it's far less true today, but back in those 1870s and through certainly that 19th century, agriculture was the use of the land in this state. There wasn't much else. A little coal mining, but basically it was all being used as grazing land or a little bit of farmland for agriculture. So when the energy industry began to evolve in Wyoming, and thank goodness they did, or be a sad state of affairs today, but they were the invaders to many of the old timers in our industry, coming in and demanding access to land, doing one thing and another. So a little of that still sets the tone maybe for how we have to look at issues today. And probably in terms of both public lands and private lands, the single factor that I think is most important to understand if you're dealing with the agricultural community, the grazing community, is that those land distinctions and boundaries don't make much sense. You look at a map of the state of Wyoming, particularly western Wyoming, all this BLM land over here, 2 sections of state trust land in every township, and then these parcels of private land that are mostly on the more productive areas. For a cow or a sheep that's out there eating, they don't know that difference. It's all the same. And frankly, for a rancher that's out there ranching, for the most part, they're committed to utilizing that entire resource in a manner that protects and enhances the resource in a manner that is financially beneficial to them, and they don't draw those distinctions. So for many of the other uses, you necessarily have to say, well, this is on public land, so we do it this way. This is on private land, we do it another way. State land, we do it another way. That becomes challenging. We respect that challenge. But I think believe that there's some things that can help address that, and that is by just everyone recognizing what that rancher perspective is, that this is a whole, it's a unit. And what you do on this particular 10 acres here, certainly it's easy to address what's the impact on the 10 acres. But the harder thing to understand and often to address is what's the impact on the ranching operation? What's the impact on where the cows are going to be on a given day during the year? What's the impact on the total amount of forage I have available? And how do I make up for what I may lose here temporarily somewhere else? Do I have additional forage? Do I have to buy hay? Those are all factors that come in. And not that the energy community can resolve those, but I think the energy community being understanding of those as sort of a background when you sit down and do business with the ranching community, particularly with public land grazing lessees, that's very key to how that can move forward. And the other thing that, and this goes to the federal agencies, and they too tend to think in terms of their parcel of land. BLM is responsible for managing this piece. That's your private land. You have total control over that. But most of the activities that take place have a direct or an indirect impact across those boundaries. And that's the thing that I run into the most, the challenge that's greatest in terms of all of us working together. With mineral companies, with renewable energy companies, landowners can usually work out the financial component of it. And I would commend the companies that in recent years in particular, they've been very productive and proactive in coming forward and making the financial part attractive in terms of compensating for the impact on the land. It's harder to understand and even calculate what that compensation should be for the impact on the ranching operation as opposed to on that piece of land. And I think that's where there's room for some discussion and some ways to enhance how we all work together. And my final point at this time would be that I can't overemphasize the need, whatever the interests are, whether it's energy or whether it's recreation. For ranchers who are busy out on the ground every day, public meetings just don't do it. In fact, frankly, they're almost a waste of time. And it takes the added initiative to go sit down with that rancher, perhaps that rancher and the neighbors, and discuss this, explain what's going to be done, what the short-term impacts are going to be, what, if any, are the long-term impacts. And that builds the relationships that I see increasingly across this state are very positive for both the energy industry and for the agricultural industry. But it does take those extra steps, those extra initiatives right from the beginning.
Great. Thanks, Jim. Let's talk more about the requirement in FLPMA that the BLM manages its lands for multiple uses and sustained yield. Phil, can you talk about how the BLM functionally balances this requirement?
Yes, I can. But when we talk about multiple use sustained yield, and I said before, what does that really mean? And it's not quite like the old Supreme Court definition of pornography. I know it when I see it. Multiple use sustained yield is a deceptively simple term that's very difficult to put into practice on the landscape. And one of the things, driving from Cheyenne to Laramie, you go along I-80 and you can see a wind farm, you can see a data center, you can see cows in the field, you can see some pump jacks. Multiple use sustained yield does not mean that every acre of BLM land has to have every use on it. Instead, it's a balancing act. And the way that balancing act works is through the resource management planning process, where BLM looks at the condition of the landscape, looks at the lands and said, okay, which areas are very important for recreation, which are important for mineral development, which are important for grazing leases. And so it's essentially a process that BLM inventories the lands, looks at conditions and the most appropriate uses with those constraints of the physical characteristics of the land. So easy to say, hard to do, but it doesn't mean that every use has to be everywhere. And there are cases where you can have coexisting use. And that's really important, is to the extent that those uses can coexist. So we could have a whole conference on multiple use sustained yield. And at the end of the day, I think people would just be, okay, I kind of know it when I see it, but there are lots of court cases that beg to differ with that.
Great. Thanks, Phil. Joe and Jim, can you weigh in with your perspectives on how the multiple use mandate may affect, or what does it mean for your different industries?
Joe indicated I should begin discussion, so I will do so. A little bit back to my earlier comment, we were the traditional use out on all these lands, so we have had to accommodate these multiple uses. I think in general, we've done it well, and we certainly are big supporters of a multiple use of these lands. But actually, I think we're less impacted today by the use of the lands, whatever that use may be, than we are by the attempts to sort of restrict uses of that land. It's the restrictive part of it that's done by the BLM and the other federal agencies that is most fearful and most impactful to us. It's not the uses that take place that we can generally accommodate.
Yeah, I agree with Jim. And the reason why I asked Jim to go first is if you're going to be in that part of the world, you should make sure you're always on the same page with the Wyoming Stock Growers Association. But I think, from our perspective, multiple use means recreation, it means development, it means ranching. And I think when you think about energy projects and you look at the landscape of the integration and the disbursement of federal lands with fee lands, it's very difficult to do projects just on fee lands, which means that you have to deal with federal lands. And what multiple use has become for us, I think, in the energy sector is, if I go do a deal with a private landowner, I know that the deal is done. On the federal level, there's so many different phases of permitting, going through the NEPA process, APDs, things of that nature, that can all be challenged in court, that it brings a lot of uncertainty into the project. So I think from some perspective, from the energy standpoint, going through the multiple use, it's a risk. We're a little bit more fortunate to date on the carbon sequestration project, where it's to some degree, it's a little bit simpler. The pore space, and I think we'll hear about this a little bit more from Phil, but pore space is treated as a right-of-way, so multiple individuals can have access to that same pore space. The way I understand it is that the Wyoming Department of Environmental Quality, who's responsible for the Class 6 permitting, will then determine really who can put a well on that pore space, which I think is a combination of who's there first and then who will have the fee acreage surrounding that space.
Great. Thank you both. Brian, can you share some insights on historical multiple uses as well as new emerging multiple uses on maybe particular BLM lands?
Yeah, absolutely. So if you look at what the BLM logo used to be originally, it was 5 individuals, right? And Phil can correct me if I'm wrong, but there's a surveyor, there's a logger, there's a rancher, there's an oil worker, and there's a miner. And so that sort of gives you a visual sense of how the agency historically viewed this multiple use mandate, right? And it really was an emphasis on these different uses, as Jim said. And that has really changed over time. I think one of the biggest things that's changed, probably globally, but certainly in the United States over the last 50 years, is an increasing sort of emphasis, as an economist, I would call it willingness to pay for environmental protection or conservation, an increased value ascribed to intact landscapes. And there's a variety of reasons for that. One of the reasons, as Joe mentioned, is just there's more recreation than there used to be. You can look at trends over time. There's a lot more recreating going on, probably on BLM lands in particular, as our national parks have gotten crowded and folks have looked for new places to recreate. So that's a new use of the land that didn't used to be there before that can create some new conflicts. And the other thing is that through advances in economics and ecology and other disciplines, we know a lot more about the ecosystem services that come from these lands than we used to. So 100 years ago, we mostly viewed the landscape as a thing to be used for these 5 uses that I spelled out. And we now understand that actually there are some important ecosystem services that provide value to society from leaving some landscapes intact. Now I think that makes the multiple use mandate that much harder, because it essentially creates a new set of demands on the same landscape, and that's a really difficult thing to navigate.
All right. Well, speaking of difficult things to navigate, let's talk about how the BLM reconciles potential conflicts between various users and uses. Phil, do you want to go first? And then Jim, I'd love to have you weigh in on this question as well.
Sure. Before I do, what's the mascot of the Forest Service? Does anybody know? Smokey Bear, right? Yeah, Temple knows all these things. All right, I'm going to give you a harder one. What was the mascot of the BLM? Just think, this is kind of the late 70s. Does anybody know? And it's not Rocket the Wyoming, the Wyoming antelope that appears on BLM's Wyoming website. It was Johnny Horizon. It looked like this Marlboro Man guy. You could Google Johnny Horizon, and that BLM tried this in the 70s. It didn't quite work. So we don't have somebody like Smokey the Bear. We don't have anything. But when we get to reconciling conflicts, Jim mentioned two of the things. Accommodation is a big term, but before you even accommodate conflicting uses, BLM attempts to deconflict through its land use planning process or its permitting process so that we don't set up a situation where we will have 2 different users conflicting over the same piece of ground. An example can be mineral conflicts. Down in New Mexico, there were a lot of conflicts between potash mining and oil and gas development that led to some secretarial orders to try to figure it out. We had some cases here in Wyoming in the Trona patch between oil and gas and Trona. We also had a case between oil and gas and coal recently that went up in the state courts in Wyoming up to the Supreme Court. And on the federal side, it came to the 10th Circuit and then back down. That was the Bear Energy Peabody dispute. So it was 2 little stripper wells in the way of the long wall of a coal mining operation in the Powder River Basin. And there was an old solicitor, one of my colleagues who's long retired. He wrote a memo that first in time is first in right. That's not really the way it works anymore. And Judge Skavdal, in his opinion at the district court level for the Bear Energy case, agreed with BLM that accommodation is more the way to do it. How do you accommodate? You look at the relative values of the uses. You look at the temporal aspects. Can one wait till the other one goes? Can they Can they partition things off to make it work? But at the very essence of it is a term BLM likes to call deconfliction. Whenever you get into a permitting process, one of the first things is look at what other uses are out there. Look at the land use plan to ensure that it's consistent with the allocation decisions in the plan, and then try not to set yourself up for these conflicts. But if you do, try to work out a way to deconflict. You know, there's the old pictures of how water rights were resolved in the West, you know, with the picture of the guy with the shovel banging the other guy over the head with it. We try not to be in that position. So accommodation is pretty much the way that BLM deals with it now.
Great. Thanks. Jim, do you want to weigh in on this question as well?
Just briefly on this one, because I certainly agree with the role of accommodation. I think one of the challenges that we face in dealing with those things is that in making their decisions on accommodation, certainly BLM considers existing uses, and which grazing is one of those. But again, they consider the impacts on the available forage for grazing, the animal units that we're to utilize. What they don't consider, and I think would be very difficult for them to consider, and this is back to my earlier comment to some degree, what is that broader impact on the integrity of the ranching operation when that use takes place? Can it be done in a manner that minimizes the integrity of the impact on that operation, or is it necessarily going to require significant changes in the way I operate, not just on that piece of public land, but on my private land and on my entire operation? And the disadvantage on public land is that if I may have to do that, but there's no compensation for doing so. It becomes an obligation that the BLM imposes on me, where on my private land, it becomes a negotiated agreement. I'll do these things different, but here's what I'm getting in terms of financial assistance or some other type of assistance for doing so.
Great. Thank you both. Let's move on and talk a little bit about CCUS and what some of the challenges are that are associated with surface access for new technologies like CCUS. Joe, do you want to start? And then Phil, if you want to weigh in with the BLM's perspective.
Yeah, so, there's a couple things that make Wyoming really unique for carbon sequestration. Number one is that the state legislature, from a statutory standpoint, said that the surface owner owns pore space. Number two is that the state of Wyoming is one of, I believe, 3 states that has primacy over the Class 6 process. And then the third one is that the Wyoming legislature passed legislation that 20 years post-injection, as long as the science shows that the wells have been properly plugged and that there's no leakage standpoint, the state of Wyoming takes over liability for that CO2. And when you think about both the liability standpoint and the pore space ownership on the dealing with fee owners, that certainly makes it easy, right? Because for the most part, we haven't seen any split estate with pore space yet. So when we're going and working with surface owners, we are leasing pore space. And it allows us to work with, at this point in time, we're just working with the same entity. So the economic interest is aligned for the owner to have both pore space and to give us access to be able to inject CO2 so they can get their injection royalties. From the federal level, I think at this point in time, it's very much the same as working with, any entity that needs it. If I needed a pipeline right of way or any surface right of way, everything is done from that standpoint. I think the one thing that we are working on is, as I mentioned, state of Wyoming pore space surface owner owns the pore space. So the BLM until recently, I don't think had considered how do we lease pore space. And I think Phil talked about it a little bit more, but it goes through a 299 process, which is a right of way process. From an operator standpoint, we work with the field office. The field office has to work with the state office. The state office has to move up the ladder. And so there's just always a little bit of uncertainty in terms of what does that process ultimately look like?
Thanks, Joe. Yeah. Two other things that the state of Wyoming did that's very helpful for carbon sequestration projects. They did the Wyoming Pipeline Corridor Initiative, in which they proposed a series of corridors for pipelines where the BLM did the NEPA analysis on those before they were done, so that it was kind of a if you do this, they will come. Not quite the field of dreams of the baseball field and the cornfield, but BLM mapped out these corridors for pipelines. So there are corridors within Wyoming to move things around. The other thing the state did was create a unitization statute for carbon sequestration projects, because as Joe mentioned, you have different ownership patterns within the subsurface, and the unitization statute allows it all to be treated as the same. But remember when I started, I talked about the property clause and the different statutes that authorize the BLM to do certain things? Well, we had the Inflation Reduction Act, and that included the tax credits. You heard 45Q right? Those are tax credits that make it financially viable for companies like Frontier to go into the sequestration business. So Congress was great. Hey, if you do this, we'll give you these tax credits. And we have the Safe Drinking Water Act that says, here's how to permit an injection well. And we have Class 6 injection wells, and they have delegated primacy over that program to the state of Wyoming. That's great. Look at BLM's regulations. Where does it say, here's how you get a permit for carbon sequestration? Here's what you have to do. As Joe mentioned, we're doing it through FLPMA with Title V right-of-ways. It would have been really nice for Congress to say, here's how you're going to permit these. And so instead, BLM has had to say, okay, we're going to fit this into our existing authority under FLPMA. We'll offer these right-of-way grants. And typically, right-of-ways are not forever and ever and ever. And so BLM's regulations have not been changed, but what BLM did was put out some policy that says, here is how we're going to do that in an instruction memorandum. And if you Googled BLM IM carbon sequestration, you'd find it very quickly. But that IM says we're going to use FLPMA, we're going to use right-of-ways, and the important thing is that those right-of-ways are non-exclusive, so that the permitting authority, which is the state of Wyoming, permits it, but the legal authority to do it rests with the owner of the pore space. You've got two different entities that are part of this permitting process. It would have been really nice if Congress spelled that out on federal lands. Here's how you do it. Absent that congressional direction, BLM uses the right-of-way process. An applicant comes in, asks for a right-of-way. It has to go through a review within the field office. Then it has a NEPA review. There are a couple, if you go on anybody heard of e-planning? Again, Temple knows everything. So if you look, e-planning is the BLM website where all the projects appear and the status of where they are in processing and their NEPA approvals. And we have two applications that are being processed. One environmental assessment is already out there for Southwest Wyoming. Another one is almost ready to go for Southeast Wyoming. And Joe mentioned Frontier. There are different ways to do this because there's no clear direction. So Frontier has gone first to the state permitting authority, said we want to get our state permits first, then we'll get our federal authorization. Other companies have said we're going to do our federal authorization, then we're going to get our state authorization. So it's not quite that BLM's making it up as it goes along, but what it's doing is using its existing authority to try to make it work in a way that is cooperative federalism between the state and BLM.
Okay, great. Thank you all. Let's move on and talk about ways to reduce the impact to the surface. So what are some tools that are available to minimize that environmental impact, such as land clearing and infrastructure development? Joe, do you want to speak first? And then maybe Jim, if you've got some thoughts to weigh in as well.
Sure. I think the carbon sequestration is a little bit interesting because what you're doing is you're looking for very prolific reservoirs that allow you to put well bores that are a lot larger than what you typically would see in oil and gas. So, we will be injecting rates that are probably upwards of 10 times rates that you would typically see in a water disposal well or an injection well and in a CO2 flood. So that by itself has some limiting impact in terms of how much surface disturbance you would need. I think if you take a step back more broadly, thinking about oil and gas as a whole, I was actually thinking about this as I flew over Denver the other day, because if you fly over the Jonah Field or Pinedale Anticline and you think about technology that was 20, 25 years old, and you look out there on the pad development with vertical wells, there are pads everywhere. But when you fly into DIA today or fly out of DIA, there is a similar level of development that's happened underground, but you don't see near the pads. And the technology that folks talked about earlier today, drilling 3-mile laterals, looking to extend that, drilling multiple wells from those pads, I think is truly a testament to what industry has done to minimize the surface impact and be more efficient with capital.
I think that there's a lot that industry does to minimize surface impact, but the one point I would draw attention to here is it can be key in where that impact takes place. And the more discretion that industry has, limited, of course, by the resource they're trying to deal with, but to locate those surface disturbances in the area where the impact is minimal, that can be very critical. That's where, again, we run back into the land ownership pattern. Often surface disturbance takes place on the private land because, as been acknowledged by others, it's so much easier in most instances to work out suitable agreements to proceed with that. And yet, because of the land ownership patterns in much of the state, due in part to homesteading acts, and in fact, we homesteaded the more favorable land, those are the pieces of land where the broader impacts on the ecosystem are the greatest. And I don't know how we move beyond that, but if we can make those decisions based on a look at the whole rather than being driven to make a decision based on the ease of negotiating agreements, that would be very helpful.
All right, terrific. Thank you. I have one more prepared question, and then we've gotten quite a few questions coming in from the audience. So I think we'll maybe skip the rest of our questions so we can make sure we get to the audience questions. Jim, I want to follow up with you. Maybe if you can share some final thoughts with the audience about what are some of the biggest challenges that livestock producers face on both private and public lands, and how might operators be sensitive to those challenges and think about working proactively with livestock producers?
Well, I think one of those challenges often is timing. So where you're able to work out arrangements to say certain activities will take place certain time of the year when the livestock don't happen to be there, or when there's alternatives, that works well. Good advance notice so that the rancher can make plans. Maybe they're in a grazing system and they can revise that system somewhat for the years that the disturbance is the greatest, so that they minimize those conflicts. I think those are the type of things there that are, there are a number of tools. It's not going to work in every case well, but the willingness to explore those tools and early in the process, that's the point I would emphasize. Whether you're dealing with private land and a private landowner, or with public lands and a grazing permittee or lessee on those lands, the earlier that you begin communication with those people, the more likely it is that it's going to come to a mutually agreeable conclusion.
All right, great. Well, we've got some terrific questions that have come in from the audience, and if you have more, please write them down and pass them up. Brian, this is a question for you, and I hope this came from a student because it's a good one. But it asks, how can a scientist or an engineer incorporate, or at least consider, surface issues in their research?
Sure. I suppose it depends on what type of technology you're interested in, and what type of surface issues you're interested in. But I think One thing that Jim mentioned that really struck a chord with me is the extent to which, if you look at a land ownership map of many states in the West, but especially Wyoming, it seems like it just makes no sense. And in a way, it doesn't. So much of the sort of land ownership pattern that we have is just hangover from westward expansion and policies that were designed over 100 years ago for very different goals. And so I think a really important starting point is just kind of cutting in and out here, just understanding who owns what and what the institutions are on those different parcels of land. Phil outlined some of the different policies that govern public land. There's other issues that can arise on private land. There's contracting costs associated with having to deal with a bunch of different landowners. And so I think the starting point is just understanding the overlap between the surface issues that you care about, whether it's habitat or air quality or water quality, and then the land ownership regime and what that looks like. And then that's kind of the starting point, is just figuring out who's going to be at the table and how do ownership patterns affect those resources.
And I would just like to go back, that agency that came into effect in 1812, the General Land Office, while they're no longer there, BLM is there. And you can go into any BLM field office if you want to know who owns what in terms of federal lands. And I would also suggest, because, we're here in Wyoming and we've rarely talked about, I dare say, sage grouse. But that's something where you can look at issues in terms of ownership, resource conflicts, and everything else, and that evolving and ongoing planning process for sage grouse habitat. You could, if you're looking for research and how those issues get worked out, that might be something to look at.
Great. The next question has to do with direct air capture. And so the question is, in the future, what would a direct air capture hub look like on public lands? What would the permitting process look like, maybe? So if anybody wants to weigh in and answer that question, that'd be great.
I can't speak to what would be required from the permitting standpoint on direct air capture. So our project, we were affiliated with a direct air capture company called Carbon Capture Inc. I think they just recently announced that they've given up on the state of Wyoming. They said there's not enough clean power here, which makes their life cycle analysis not work well. Just for clarity, our project is, we want to do the transportation and the sequestration of the CO2, and we're agnostic to where the CO2 comes from. We think that the more CO2 that comes to the site makes it the cheapest for all customers, but we've been focused primarily on the industrial emissions located in the area. But Phil?
Yeah, so the permitting process for that would be the same as for if it's on federal lands and you want to put a facility on federal lands, the DAC hub or whatever infrastructure needs to be there, you'd have to have right now a right-of-way under Title V of FLIPMA, because that section allows for reservoirs, pipelines, but not oil and gas pipelines, because those are in the Mineral Leasing Act, so nothing is ever completely simple. But also the catch-all in FLIPMA, other facilities in the public interest. So there's all types of things you can do on public lands if it's in the public interest. But right now, the regime would be a Title V right-of-way, submitting an SF-299. That's the form you submit to get the right-of-way grant. And again, the right-of-way grant for DAC would be slightly different than for actual sequestration, because again, for BLM, they will give a subsurface pore space right-of-way, but they will have it conditioned that you cannot start to inject until you get your state permit. So you can have a right-of-way grant that gives you the legal right to do something, but then you have to have a notice to proceed. That notice to proceed is conditioned on the state permit. For a DAC facility, if you're just capturing it and putting in a pipeline and you're not putting it down in the ground, it would be the same as a right-of-way for any other infrastructure on federal lands.
Great. Thank you both. That's helpful. Jim, we have a question for you. Wondering if you could discuss surface use agreement development in the fast-paced environment we're in, where industries are changing, personnel and company ownership are changing. So if you could discuss surface use agreements in sort of that context. That'd be great.
Well, certainly surface use agreement can be challenging, but now I presume we're talking about private lands here, private surface, and negotiating those agreements. And I think there's a couple of things I would say to keep in mind. One is that certainly the revenues that a private landowner can derive from energy development, whether it's renewables or oil and gas or any of those, can be very significant. And in fact, in today's economics in our industry, they can be the difference between keeping a ranch operating as a family ranch or having it evolve into something different than that. And I think that's important. But the other thing that I think is really critical is that dollars aren't everything. And most of the ranchers, the family ranchers that I know, have pride in their operation. They have pride in what they put together. They want their children, their grandchildren, to inherit not just land, but that workable operation, that viable operation. So I think to the extent you can reach out and say, well, here's what we need to do, but maybe here's a couple of different ways we could do it. Which of these would be most accommodating? Those types of conversations, again, I think are really the key to something that can be positive for both parties.
And just to add to what Jim said, under the Stock Raising and Homestead Act from 1916, I think, it essentially said you can go out and you can homestead lands and you get title to the surface, but you don't get the federal minerals. In those cases, we have what's called split estate. In split estate situations, it's always more favorable for an energy developer to reach an accommodation, a surface use agreement with the landowner, rather than then, if they can't do that, there's a provision in the Stock Raising Homestead Act that allows the energy operator to post a bond. And those bonds used to be just for damages to crops and tangible improvements. And then that involved also to forage. But those bonds never really take into account the characteristics of the ranch, what's going on, the things Jim mentioned. Whenever BLM is out doing on-sites for oil and gas, they always, in a split estate situation, try to get the landowner involved as well. Is there a way we can move this pad here, there? So to try to involve it, it's all about communication. And it's better to get an agreement with the landowner than try to have to go back and then get a bond and post the bond under the SRHA.
All right. I think we might have time for maybe just this last question, and it's a good one. So I want to make sure we get to it. But it's talking about the BLM's new conservation planning rule. And the question asks, is conservation a legitimate land use under FLPMA? And if so, how do you navigate that?
I think that's a question for the senior attorney in terms of whether it's legitimate under FLPMA. Yeah, I mean, I can't comment. My understanding is that the answer is yes, specifically under FLPMA. I can talk about it from an economist perspective, which is, does it make sense to think of conservation as a use? And as an economist, I think the answer is yes, because the way we think about the environment has really involved to think about what are the flow of services that we get from the environment. And that might be clean air, it might be clean water, it might be nice views, it might be, the potential for biomedical breakthroughs. There's all sorts of different things. And then we think about what is the value associated with those services. And that's really how we put those things on even footing to do apples to apples comparisons with traditional uses of landscapes or extractive uses. And so from an economist perspective, I think it makes a lot of sense to think about conservation as a use that we can trade off with other uses, but I'll let Phil speak about the law.
And it positively is a use under FLPMA. Recall when FLPMA was first passed, before it was even passed in 1970, the first bill that was introduced dealt with recreation as a use. And part of conservation as a use, you can also include recreation with conservation to the extent that they're not going to that we mentioned national parks can be so crowded that they have to limit use. But conservation is definitely a use. The new public land law explicitly recognizes that. However, there is litigation associated with that. And if I talk about that Supreme Court case again, was Congress explicit in FLPMA to say that you can have conservation leases? That's a question yet to be answered, but it's worth thinking about.
Jim, I'd let you have the last word on this one if you want it.
Recognize that there is a legal challenge, because I think as far as conservation leasing, that's still undecided from a legal perspective. But my final point would be that what concerns me is when we make conservation a use of the land, sort of implies that all of these other multiple uses don't involve conservation. And to me, conservation is the way in which we use the land, whether it's for mineral development or livestock grazing or recreation. We all need to approach our use of the land with a conservation ethic. And I'm concerned that identifying it as a use is going to take some of the focus off of all of us considering it to be the ethic by which we utilize the land.
Great. Well, please join me in thanking these experts for their time and thoughts today.